Good afternoon. This is Dr. Olu Asekun here. Welcome to our weekly podcast. Today is another beautiful Wednesday. And as we start today, please invite your family, friends, colleagues at work so that they can all benefit from this free flow of information. What's today's topic?
uh, Actions that can prevent you from becoming a U.S. citizen.
Okay, so today we are discussing issues that prevent people from becoming a US citizen. There are so many things that can prevent someone who is a permanent resident from becoming a US citizen. And we see this all the time. So that is what we want to discuss today. What are those things that can prevent a permanent resident from becoming a US citizen? That is the topic. So again, invite your friends, family, colleagues to join us. If you have questions, send in your questions. Can you please post our numbers?
Mhm.
Our numbers are 817-883-4495, 817-983-4499, 817-891-6655. So send in your question and we will answer it. So, what are those things that can prevent someone from becoming a US citizen? There are so many of them. Can you please let me get into the question? I want to know when questions come in. And there are so many things that can prevent a permanent resident from becoming a US citizen. So, some people they believe that it is only criminal matter. Yes, criminal matters can prevent someone from becoming a US citizen, but there are additional things that can prevent someone from becoming a US citizen. In fact, there are so many things that can prevent someone from becoming a US citizen. Thank you. So, how will I see when questions come in?
You will see it from here. They're gonna show up on the screen.
They will just show up by
Yes.
itself. Okay. So, there are so many things that can prevent someone from becoming a US citizen. So, we are going to start. The first one, which is the most popular thing among different people, the first one is criminal matters. Everybody knows that. If you are a permanent resident and you are convicted of certain offenses, in fact, major offenses, even misdemeanor offenses can prevent someone from becoming a US citizen, especially if it happens within the first 5 years of becoming a permanent resident. So, criminal issues can prevent anyone from becoming a US citizen. So, if you have questions, send in the question. I know that as we receive questions, I'll be able to elaborate on the kind of criminal things that can prevent someone from becoming a US citizen. For the purpose of this introduction, at least for now, suffice to say that criminal matters can prevent someone from becoming a US citizen. Secondly, still talking about criminal matters, even when we are talking about criminal matters the same crime. It is important that I explain this. You can have two people, two different individuals who are permanent residents, and both of them committed the same exact offense. And one of them may be eligible for citizenship, the other may not. You will be wondering if those kind of people, if they use two different lawyers, the one who is eligible will believe that the other lawyer does not know the law, does not understand the law, does not understand how this thing works. But that is not the truth. That is why it is important that you get this explanation. There are some minor offenses or even misdemeanor offenses that can prevent someone from becoming a US citizen depending on the timeline, the time of the offense. For citizenship purpose, there is something called crime of moral turpitude. The first 5 years of becoming a permanent resident is key. So if you committed any of these offenses within the first 5 years of becoming a citizen, it can disqualify you. Whereas somebody else who committed the same offense, but after 5 years of being a permanent resident, it may not have the same devastating effect on the person. So immigration law, as I always say, is very, very technical, and it is very important that we understand exactly how our individual situation is in order to make an informed decision. So that is about crime. But crime is not the only thing that prevents someone from becoming a US citizen. Let me go into the second thing. If you look at the application for citizenship, there are some questions that they always ask. Are you owing the IRS? Debt to IRS can actually prevent you from becoming a US citizen. Again, this will be considered, it will be, USCIS will believe that the applicant lacks good moral character. Because if you cannot obey simple rules of paying your taxes, why would they reward you with US citizenship? It is the tax income that they use to develop this country. You want to be a part of the country, but you don't want to play your role. You are not yet a citizen, you are already avoiding tax. So what happens when you become a citizen? So that is a qualification. In fact, let me say this. Even if you have a payment plan agreement with IRS, your application can still be denied. And I'm talking from experience. I've seen clients who was owing IRS, had a payment plan agreement with IRS, did not miss any of the payment, was paying as at when due with the IRS. But the officer still believe that for him to not pay his taxes as at when due in the first place shows that he lacks good moral character and deny the application. We have two options: either to file an appeal against that decision, or to get him to pay the taxes. So in that particular case, I advise him to go and pay what he was owing IRS. So he paid off his taxes, and then we reapplied for citizenship, and this time around it was approved. Still in the same vein, simple things that we do that we don't even know that have major impact in our lives can actually prevent you from becoming a citizen. For example, citizenship can be denied if immigration believe that an applicant is a drunkard. Now, it is important why I'm bringing this thing up. We all know and we always believe that until somebody is convicted of a certain offense, that is the only time citizenship can be denied. That may be true, but citizenship can also be denied even when the client has not been convicted. If they see a pattern, that, okay, this person always get arrested for DWI, even though at the end of the day you get the best lawyers, they get the case dismissed. The next time you get arrested again, DWI, you got the lawyer maybe to put you on probation. The next time, so when they see that pattern, they deny your citizenship. Remember, this is an area that immigration has a lot of discretionary authority when it comes to good moral character. They have a lot of discretionary authority. So in concluding that somebody lacks good moral character, if they see a pattern, how is it that you are always being arrested for DWI? So you must be a drunkard. Citizenship could be denied on that basis. I'm talking from experience. These are cases that we have seen happen. Another thing that is not criminal related, or maybe it is even criminal related, if before you became a US citizen, you already voted in an election, in a federal election in the United States, it is a ground for denial of citizenship because non-citizens are not required to vote. Only US citizens can vote. A voting right is one of the exclusive benefits of US citizens. So if you are not yet a citizen and you have voted in an election, if immigration found out, you are disqualified from becoming a US citizen. Again, you don't have to be arrested or convicted or anything. That is another ground that can disqualify you from becoming a US citizen. Now, the most common, what I will consider the most common ground that a lot of people don't pay attention to, which can also deny you US citizenship, is what is called physical presence. The law requires that any permanent resident applying to be a US citizen must be physically present in the United States for a certain number of days or weeks or months or years, depending on your category. I didn't use the word days by mistake because there are some categories where you are required to be a permanent resident for 1 day before you can apply for citizenship. There are some categories where you are required to be a permanent resident for 3 years before you can apply for citizenship. There are some categories where you are required to be a permanent resident for 5 years before you can apply for citizenship. So depending on your situation, but the fact remains that in all of them, there is a physical presence requirement. So you are required to be physically present in the United States for certain number of days, months, or years. Now, if you don't meet the physical presence requirement for your category, then your citizenship application is going to be denied. I see a lot of things that people post online, a lot of misinformation, a lot of informations online that are not true, even on Google, on YouTube, informations that are not true. Some people will say that, oh, if you stay out of the US citizen, if you stay out of the US for 6 months, whatever number of days, weeks, months, or years that you have accrued will be eliminated, will be cancelled. So you have to start the counting all over again. So if you are required to be physical present for at least half of 5 years, if you have spent 2 years in the US and then you travel out and you stay 6 months and you come back, that 2 years will be erased. So that 5 years, you start all over again. So there all these things can lead to denial of citizenship application. I think there are questions coming in already. Okay. The first question: am I required to disclose all past arrests and convictions? Oh yes. Oh yes. Remember, you cannot become a US citizen without going through biometrics. So even whether you disclose it or not, they will know. So, of course, if you disclose it, if it doesn't disqualify you, you get your citizenship. But if you don't disclose it, it will add to the problem because now it becomes misrepresentation. Now it becomes additional offense of lying to the US government, lying to obtain immigration benefit. So you are adding to the problem. Say, yes, you have to disclose all arrests and all convictions. The next question: how can I demonstrate good moral character despite my criminal record? Well, it depends on the nature of the crime. As I explained before, there are so many factors that affect the ability of somebody who has been convicted of a criminal offense from becoming a US citizen. Number one, the timeline. When was this offense? When were you convicted? Was it within the first 5 years? If it is within the first 5 years of your green card, it carries it is more devastating. It has more impact. It has the likelihood of preventing you from becoming a US citizen. Two, what was the nature of the conviction? You see, for immigration purpose, immigration does not rely on only conviction documents. If you are going to apply for any benefit under immigration law and you have a criminal offense or you have been convicted, immigration is going to request three things from you. Immigration is going to request police incident report. I'm not talking of police report. Incident report is different from police report. Immigration is going to ask for police incident report. They are going to ask for charges. What were you charged for? And they are going to ask for conviction. So all those things. So the reason police incident report is very important is because immigration is going to look at exactly what happened. They are not going to rely entirely on the conviction because they know that on the conviction part, I mean, when you see creative lawyers, they get the case modeled up, and at the end of the day, the person is convicted of a lesser offense or convicted of misdemeanor, or even have the case thrown out in the first place. So they look at all these things. So that is why they look at the police incident report. At the time that somebody called 911 and the police went out to the crime scene, what exactly happened at that moment? What did the police find out? Immigration rely heavily on that. So still on that question of demonstrating a good moral character, if the offense is not a felony, time may heal it. For example, if the offense is not a felony and it happened, you are not going to be eligible for citizenship, but you wait it out. Make sure that you wait another 5 years from the first 5 years. Wait another 5 years. Make sure there is no criminal issue. Make sure you don't have any problem with the government. So you wait it out. It is still discretionary. Immigration is still going to bring it up. But if you demonstrate over time that you are a changed person, sometimes they may still approve it, but you have to wait it out. And during the waiting period, you make sure there is no issue. And that is only if the offense is not a felony. If the offense is a felony, that one, you cannot become a US citizen, irrespective of how long it has been, especially if it's an aggravated felony. Even the green card may be taken away from you. The next question: will I face deportation risk due to my criminal record? Well, that was just the last sentence I made. Yes, if your offense is a removable offense. Now, immigration law has created a very, very extensive list of what constitutes aggravated felony. And I believe we have a topic on what constitutes aggravated felony. Do we have a topic on that?
We've discussed.
For immigration purpose.
We've discussed it, but like not as.
Can you note it? That's a topic. What constitutes aggravated felony for immigration purpose, so that we can discuss it. So it depends on what the offense is. Like I said, immigration has a very long list of what constitutes aggravated felony. There are some offenses that you and I will see as very minor, and in fact, the conviction at the criminal court may even be minimal. I've seen cases of people whose conviction was 12-month probation. They didn't even go to jail for 1 month, and yet it constitutes aggravated felony. It depends on the element of the offense. As I stated, immigration looks at the element. They don't look at the offense itself. They look at the element of the offense. For example, if somebody got involved in fraud and the amount defrauded is up to $10,000 and above, that for immigration purpose is aggravated felony. So it depends on a number of factors, but someone who committed aggravated felony will likely lose his or her green card. There are very, very few exceptions for people who are eligible for 212H waiver. Very limited exception, but most people, when you commit aggravated felony offense, it is a ground for deportation. It's a ground for removal from the United States. The next question: can I apply for any waiver or relief in my criminal history if my criminal history disqualifies me? Yes, like I just said, not in all cases. In very limited cases, somebody may be able to apply for a waiver. I don't want to go into that now because it would take us completely away from the topic of today. But I think we have a podcast on waivers, criminal waivers. So if anyone wants to have more information on that, you can check our podcast on criminal waivers. So yes, in few situations, someone can be eligible for a waiver, but not not in all cases. Very, very limited situation. Somebody who is convicted of aggravated felony may be eligible for a waiver. Next question: do I need additional documentation related to my criminal record when applying for naturalization? Anyone who has ever been arrested, not even convicted, anyone who has ever been arrested and anyone who has ever been convicted, whenever you apply for citizenship, you have to get police incident report, you have to get the charges, and you have to get the conviction record and submit all of these together with your application. And even if you didn't, USCIS will ask for it, because once they run your biometric, once you go for fingerprinting, they will see all this arrest record, and then they will issue you a request for evidence for you to submit them. But yes, you will need to submit it in order to become a US citizen. Next question: how will this affect my immigration status if my application is denied? Well, this one depends on the policy of the administration in place at the time you apply for citizenship. For example, if your citizenship application is denied, sometimes they will just leave you and not do anything, which means you can continue to use your green card. But again, depending on the administration in power and their policy, sometimes when the citizenship is denied and it is based on criminal ground, they can go ahead and put you in removal proceedings. And when that happens, of course, if you are eligible for a waiver, you apply. If not, you may be on your way out of the country. The next question: what should I do to prepare for my citizenship interview since my criminal record will likely be addressed during the interview? Well, this is too general a question. I mean, there's no way I can tell you what to do when I don't know what the offense is and all of that. But the thing is, it is better for you to consult with an immigration attorney who knows what he or she is doing, so that they tell you whether to apply or not to apply. Because sometimes it may be in your best interest not to apply, especially if your offense occurred within the first 5 years. So when an immigration lawyer review your case, they should be able to advise you that, look, this is not the best time for you to apply for citizenship. Don't apply. Again, the lawyer will be in a position to know what the current administration policy is on the issue of removal or no removal. For example, during this Biden administration, Biden administration is very, very lenient with people, with deporting people. They are very, very lenient. So even when citizenship applications are denied, they don't place people in removal proceedings. during Biden administration. It was not the same thing during Trump administration, and we don't know what is going to happen during the next administration. We don't even know who is going to win the election yet. So it is always advisable. The best thing, once you know that you have a criminal record, try to get an immigration attorney involved who can help you navigate this whole process so that you don't get yourself deported unknowingly. The next question: what is the selective service and how can I know if I'm registered? If I'm not registered, how can I register? Well, the selective service is not for everybody. However, any foreigner who obtain permanent residence between the ages of, I think, 18 and 25, 18 and 26, between 18 and 26, you are a male, not everybody. I take that back. Every young male, you have to be a male. It's not applicable to female. Every young male who obtains green card between the ages of 18 and 26, they are mandated by law to register for selective service. It doesn't mean that they are going to send you to war. It doesn't mean that you are even joining the military. It's just for you to register so that they know that you are there in case there is emergency, in case there is need to call on you. You have to register for selective service. So non-registration is another ground for denial of citizenship. If you don't register for selective service, it will be a ground to deny your application for citizenship. Again, a lot of people, I always tell people, the day you get your green card, if you are within that age bracket, just register that day before you forget, because it is something that can be done online. You just go into the selective service website, put in your name, address, I don't even know it. Yes, name, address, I believe date of birth and social security number. That's about it. So just do it immediately before you forget, because if you forget it, when it is time for citizenship, it will be waiting for you there and it will be a ground for denial. And to know if you are registered, just go back to go online, go to Google, search selective service registration. There is a button there where you can put in your information and check whether you are registered or not. If you are registered, it will tell you. If you are not registered, if you are still within the age bracket, you better do it before it is too late. The next question: I was charged with DWI 2 years after becoming a permanent resident. Can I still apply for naturalization? If you are convicted, I will advise you not to. I will advise you to be patient, get more time, let time waive, let a lot of time pass if you are convicted. But if you are not convicted, if the case was dismissed, yes, you can go ahead and apply. But if you are convicted, and if that, even if you are not convicted, if you have multiple arrests, it may still be a problem. But if that was the only arrest and you are not convicted, you can go ahead and apply. But if you are convicted, I will advise you to be patient. Let time heal the wound, as they say. The next question: you mentioned being a drunkard earlier. I have never been convicted of anything, but I'm an alcoholic. I went to rehab and go to AA. Could immigration find out? Well, it depends on a number of factors. It depends on a number of factors. Number one, you have to look at the questions. There are so many questions on the application for citizenship. And the way many of these questions are drafted, immigration is very, very skillful in drafting these questions. There are questions that say something like, even if you have never been arrested, there are questions like that. So if you answer such a question with no, and then they find out, even if they find out after you become citizen, it may still be an issue. So for that reason, I will disclose it. I will disclose it, but I will make sure that, number one, time has passed to show that you are a changed person. So you have to, you see, this type of question is very tricky. When people ask general question, we provide general answers. But I will advise whoever send this question to probably seek one-on-one consultation. It doesn't have to be with me, but seek a one-on-one consultation with an immigration attorney so that at least they can look at your specific situation. Because the response, the answers that I'm giving you, this is general answer. I don't know the details of the arrest. I don't know the details of what happened. But I tell you, if you are still within the first 5 years, I will seek a professional advice before taking any step further. But going to rehab by itself is not a crime. It is actually evidence that you are making effort to get yourself rehabilitated. But again, how will they know if this effort is working or not? The only thing that can show it is time. So allow time to pass. Don't apply for citizenship immediately. Give it some time. Wait for about 5 years. Show prove to immigration that you have changed, and by letting them know that, look, in the last 5 years, I've been clean. I've not been involved in anything. Because I cannot tell you authoritatively that immigration will not find out. A lot of things constitute public record, especially depending on how long you stayed at the rehab. For example, if you stay at the rehab for up to 3 months, for example, when they ask you for your address in the last 5 years, what address are you going to give? Are you going to omit the rehab? If you omit it and immigration find out later, again, it becomes misrepresentation. So this thing is very, very tricky. So it's better to consult with an attorney, let them evaluate your specific case, and then advise you appropriately so that at the end of the day, you don't regret your action. Next question. I'm a pilot and go out of the country frequently for work. Does this time count against me when filing for citizenship? Do I put all my trips for work on my application? No, this does not affect you. I mean, for as long as you are a pilot resident in the US, when you fly out of the country, that is going on a job. If the country you go to, they don't see you as coming there to visit. You are still an American. You still live in America. That is not considered. That is not considered external or trip that can affect your citizenship application. No, you are still resident here. I don't know of any pilot that will fly a plane out of the US for 2 weeks without coming back. I don't think so. So it's so when you go like that, even for under international law, those countries where you go to, they don't see you as a visitor. They don't see you coming into. They just see you. The kind of admission they give you shows that you are a flight crew. And I know that there is something like that under immigration law too. That is why they don't allow people who come into the US as a flight crew member to change status in the US. So that is part of international law. So that is not considered external trip for the purpose of affecting citizenship application.
But do they still put it on the N-400?
No, once you state your job as a pilot, you don't have to. If you have to start a pilot in 5 years, if you are an active pilot, you have to write maybe 200 pages of addresses. No, you can't do that. No, it's not required. What is required is to you to declare your job. What is your job? I'm a pilot I fly for American Airlines. That is all that is required.
What if they stay in the country for like 2 to 3 days?
Like I
As a
said,
crew member.
because under international law, those countries that you go to, you cannot change your status.
Yeah.
Crew members are given international status for the purpose of entry into different countries. So you are not considered a visitor coming to visit their country. So it is that crew member status. So you are still an American if you are using American passport, or if you have a green card, you are still a permanent resident here. So even if you fly out and stay in one country for 2 to 3 days, that doesn't count.
Oh, okay.
Doesn't
You're
count.
still in American soil somehow.
Yes,
Oh.
yes. That's why they don't allow them to change status.
Yeah. No, that makes sense.
I remember someone consulted with me last year. This person was working for one of the these shipping companies.
Cargo.
No. I'm not talking of plane. I'm talking of this one on water.
DHL?
No. When you go on cruise.
Okay. Oh yeah, they're crew members.
Yeah, when you go on cruise. So the cruise landed in Florida.
Yeah.
And of course, the person was asking if he come in, he could change the status, and I said no, you can't, because you came in as a crew member, you
You need to
cannot.
abandon your employment and stay in the United States.
Yes, you can't do that. You will not be able to change your
They're not
status.
legally admitted.
It's not allowed under international law.
Okay.
I'm trying to. Okay, I think I found the last question. The next question. I just found out that I'm owing child support. I didn't know, but I have already filed my citizenship. What should I do? You need to quickly go and pay your child support. That is a major ground of disqualification. You cannot become a citizen while owing a child support. You cannot. So before they invite you for interview, go. If you need to borrow money, go and borrow money and pay it off. If you don't pay it, I guarantee you, it will be an issue. Even if you have children outside the US, USCIS will still ask you for evidence that you are taking care of that child, evidence that you are maintaining your relationship, evidence of financial support of that child.
That's one of the questions. Are you financially supporting this child?
Yes, it is a mandatory requirement. So if you owe it and you have already applied for citizenship, go and borrow money and pay it off. The next question. I work for an American company as a permanent resident. I get paid in USD, but I was transferred to Belgium. Can I still apply for naturalization? Well, it depends on the nature and size of the American company. It depends on what the American company is doing. It depends on whether or not the US government see that company as a major trading I don't know how to describe it, but it is not every company. For example, if I decide to go and open a branch of my law office in Belgium, and then I transfer people from here to that office, they will not be eligible for citizenship because they will not meet the requirement of, they will not meet the physical presence requirement. However, if it is a company like Boeing, if it's a company like Boeing and they pay this person in US dollar, and the person is filing his or her taxes, they will still be eligible for citizenship. They will still meet the physical presence requirement, or if it's a non-profit religious organization that is involved in evangelism or missionary work abroad, yes, they will still be eligible. In fact, the not only will they be eligible, the law will actually waive the number of years for them. They may be eligible for citizenship in one day,
Just like US military.
just like people in the US military.
Okay. Fine. Last question.
I'm typing one, it's just.
Just go ahead.
Okay, so if you have additional questions, send them in. We are discussing what can prevent someone from becoming a US citizen. That is the topic we are discussing today. So if you have questions, send them in so that we can answer your questions. What are those things that can prevent someone from becoming a US citizen? As you can see, there are so many little things that people don't know that can actually prevent someone from becoming a US citizen. Something as little as owing IRS, something as little as owing child support, something as little as being considered a drunkard, something as little as voting in an election without being a US citizen. There's another thing that I forgot to mention as one of the things that can disqualify someone from becoming a US citizen. False claim to US citizenship. If you have in any way falsely claimed to be a US citizen, you are not eligible for citizenship. Let's say you are a student and you didn't want to pay as an international student. You decided to put in your application that you are a citizen. If immigration found out, it is a permanent bar. You cannot become a US citizen. Another thing, a lot of people do this all the time, and we see it all the time. I've seen so many of, in fact, I can't count the number of people that I've seen make this mistake. You already have a green card. You want to buy a house, and you put in your application you are a US citizen. I mean, come on, it's not going to give you any extra benefit. You are already a permanent resident. Just say you are a permanent resident. Even if you are not a permanent resident, there is no law that says you have to be a permanent resident before you can buy a house. Even people who don't live in America, they buy houses. So just buy the thing and in your status. But the problem is, once you claim to be a citizen in your application, if immigration found out, forget it. You can't become a citizen. So these are little mistakes that people make. Have we received any new question?
I'm almost done.
So you have to be careful. Some people, it is an agent or maybe a loan officer that help them to complete the loan application. Let them know you are not a citizen. Make sure you review the application before you sign it. Even if you sign it over the phone and they put citizen, once you see it, call their attention to it. Look, I'm not this one is not right. I'm not yet a citizen. So that they correct it. But the moment they process that application for you as a US citizen when you are not, if immigration found out, I tell you, it is. You see, in the past, I used to believe that for as long as you don't obtain government loans, maybe government loans like FHA, maybe VA loans, for as long as it is not government, it's no problem. But guess what? It is a major problem. Do you know that mortgage companies, bankers, they sell loans? I've seen conventional loan sold to the government. In fact, that is one of the things that the federal government does when they want to kind of stimulate the economy. If they see a problem in the real estate sector, they get them to encourage the lenders to keep lending so that the economy will not be affected. So they buy all these loans. Maybe the lenders, I mean, depending on their portfolio, maybe they have for the purpose of this explanation, maybe they have a 1 million portfolio. I'm just using it for the purpose of this explanation. By the time they give 300,000 loan to 3 people, they will run out of money. But what FHA or some other government agencies, what they do is that they buy off this loan so that these people will have free access to liquid cash to continue in business. So what I'm trying to say in essence is that your loan may start as conventional loan, no government related, but it may end up as a government loan when the loan is sold. It may end up as a government loan. And if that happens, again, before the government will buy any loan, they will look at the documentation. They will look at the documentation. That is one of the things that Obama did I don't know whether it was Obama who did Dodd-Frank Act. That was one of the things they did during the recession to ensure that people who are not eligible for loan, they don't get loans. That was when they introduced a third party, what do you call it? These people that will vet a loan before it is approved. Is it underwriters they call them? I think. So let's say you approach Bank of America for a loan, or let's say you approach Countrywide Mortgage for a loan. After they give you all the terms of the loan and everything, and they collect all the documentations from you and all of that, before they can close on that loan will be sent to an independent underwriter who will review all the documentation. That's why sometimes for those who have purchased houses, they probably will have encountered a situation where your loan officer will come back to you and say, oh, the underwriter is asking for this, the underwriter is asking for that. It is because they have to be sure that everything that the government requested, they are present, so that this mortgage bank will have the ability to sell the loan. Because if the documents are not correct, the government will not buy it. So again, your loan may start as a conventional loan, it may end up a government loan. So that is why if you falsely claim to be a citizen in your loan application, it can always get back to you, and it is not worth it. The risk is not worth it. Yeah. So what's the next question? It seems more questions have come in.
Yeah, the next one
The next one should be
is when I was applying for my green card, or wait. Yeah, when I was applying for
okay.
my green card.
Okay. Yeah, the next question. When I was applying for a green card, a woman claimed her baby was mine. A woman claimed. This is a little funny. If you have a child, you will know. I mean, children are not produced in the lab. If you don't sleep with a woman, you will not be talking about having a child. Okay, when I was applying for green card, a woman claimed her baby was mine. I thought she lied, so I didn't include her. I found out she's mine. If I include her on my N400, could they deny me? Well, this is not a straightforward yes or no answer. It depends on the circumstances. If you have documentary evidence of when you knew that the baby was yours, yes, you disclose it, there will be no problem. Of course, once you disclose it, immigration will ask a lot of questions. And then you show them. For example, this question didn't tell us, how did you find out that the baby is eventually yours? How did you eventually find out? Did you do DNA or how? If you did, the date that you did the DNA will show. The date will show that this was after you already got your green card. So they will not have expected you to disclose a child you are not aware of before your permanent residence. So it depends on how did you know. But if it was verbal, then you are going to be in more challenging situation, because to convince them that you didn't know will be difficult, because they may be thinking that you intentionally hide the information from the government. And of course, if your name is listed on the child's birth certificate, it even make it more difficult, because that means that on the day the child was born, the mother knew you are the father and probably contacted you. So to now verbally or orally dispute that will be difficult. But if you have evidence that, look, you didn't know, when they brought it to your attention, you challenged it, you eventually had to do DNA. It was only after the DNA proved that you are the father, that was when you decided to assume responsibility as a responsible man. That can be okay. The next question, for technically line. Oh,
Oh,
okay, that was a continuation. Okay, yeah, I already answered that. Yeah. The next question. I see that gambling could make me ineligible for citizenship. I live in Oklahoma and gamble a lot. Do I need to stop before applying for citizenship? Well, if they don't know, if they don't know, it may not affect you. But if there are records of things you do when you gamble, I've never gambled, so I don't know how it works. So I don't know. I don't know. But if you already know, if your conscience, as you are listening to this program, is already telling you you are a gambler, I tell you it's better to quit. At least suspend it until you become a citizen. Uh, the next question. What can I do to demonstrate rehabilitation if I've been involved in past criminal activities? The greatest thing for you to do is to be patient and ensure that you don't have any new offense. So be patient. Don't rush to apply for citizenship. Be patient. Green card is usually valid for 10 years. If you wait, depending on when the offense happened, if it was within the first 5 years, wait, be patient. Worst case scenario, when your green card expire, apply to renew it. Wait it out. When I say wait, minimum 5 years. Minimum 5 years. Again, if the offense happened within the first 5 years, then you wait the first 5 years. You now wait another 5 years before you apply, because the fact that the offense happened within the first 5 years, that will disqualify you automatically. So it is the next 5 years that you are actually waiting, and during the waiting period you also make sure that you don't have any new criminal offense. That way you may be able to prove rehabilitation. Rehabilitation is not by documentation, it is by your actions. When they see that they run your criminal background, no other offense, that is what is called rehabilitation. It is not by going physically into rehab and then you come back 3 months after you commit another offense. No, that's not rehabilitation. It is by waiting for a long period, showing that during those periods you do not have any criminal offense. What happens if I have a pending charge or unresolved case? Your case is going to be put in abeyance. Immigration can never, by law, adjudicate a case where the applicant has a pending criminal charges. They are not allowed to adjudicate. They have to put your case on hold until the case is over. So if the case is in court for years, your application is going to be stuck at the immigration office. Do we have more questions coming? Okay, thank you. Last episode. Okay, last episode you mentioned that joining the military of another country will not make you lose your green card. Could this keep me from becoming a citizen? No, it doesn't keep you from becoming a citizen for as long as you meet the physical presence requirement. You see, before you become a US citizen, you are still a citizen of another country. So let's say from you are from South Africa, you apply for permanent resident, they granted you green card. You are only a permanent resident of the United States, citizen of the United States. You still remain a citizen of South Africa. If South Africa law requires you to join the military, if it is mandatory, you have to. It doesn't affect anything here. The only thing that affects your citizenship, your green card here, is your physical presence. If you meet the physical presence requirement, then you are fine. It doesn't affect it. However, whenever you apply for citizenship, when they invite you for citizenship interview, it is during that interview that they are going to ask you, are you willing to pay allegiance to the United States? Those are the things that will come up during your citizenship. It is from that moment, if your citizenship is approved, from that moment you can no longer be military, even if South Africans allow dual citizenship, because you have promised under oath to owe allegiance to the United States, and there is no way you can owe allegiance to the United States and be in the military of another country. The interest will definitely conflict. So whatever you do while you are a permanent resident does not affect your green card. It is what you do after you promise your allegiance to the United States. It is what you do from that moment that matters. The next question: can I appeal the decision for naturalization? Oh yes, oh yes. If your application for naturalization is denied, if you believe that the denial was wrong or immigration was wrong, yes, you have a right to well, the appeal process, let me tell you, this is the way it is. The first one is not an appeal. You have a right to request a hearing. You see, when your application is denied, you have a right to request for a hearing, meaning that you want them to give you an opportunity to present your case. Maybe whatever happened during the interview, you believe that the officer got it wrong. So you now request a hearing by filing Form N336. So they will review the case, give it to a different officer, and then have you present your case. If they believe that the first officer was wrong, then they approve it. But if they believe that the first officer was not wrong, they deny it. It is only after that that you can you can file an appeal. And unlike every other application, when it comes to appealing denial of citizenship, you go to court. You file your appeal at the Federal District Court. It's different from, this is not one of the cases that goes to Board of Immigration Appeal or Administrative Appeal. The only administrative process that you have if your application for citizenship is denied is the right of hearing. So once you have requested a hearing and after hearing your case, if they still deny it, from that moment on, your appeal can only be filed at the federal district court. But yes, you have a right of appeal. And even if the federal district court denied it, you can still appeal to the circuit court. And of course, if the circuit court denied it, you can attempt to request the Supreme Court to intervene. But the Supreme Court of the US does not work like most other countries. They choose what cases they want to listen to and which case they don't want to look into. I believe that's the last question. Okay, so in the absence of any new question, we are going to be stopping here today. We hope to see you again next week. Remember to invite your family, friends, colleagues at work. And I believe that we are going to continue this series next week by God's grace. I understand that a question just came in. I was deported from Montreal in 2014. It's been over 10 years. What can I do?
Oh, that's
What's the factual background? I don't know. I mean,
because this is Canada. I mean, it's not the US.
Are they in the US?
I don't even understand what the question is saying, because was this based on criminal ground? Was this person applying for citizenship when he was deported? Well, I mean, there has to be more to this thing before I can answer it. The good thing is that we are still continuing citizenship series next week. Do you have the topic for next week?
Next week, are we? I thought we were gonna do the one. that you just-
I remember we talked about citizenship, 3 or 4 different.
This permanent resident citizenship.
And what can prevent you from becoming a permanent resident? We talked about that.
No. On the citizenship, we broke it down to. Anyway,
And then
we'll look at
crimes of
the
war.
last episode, and then we'll post what the next topic is. But if I remember correctly, it should still be on citizenship, because I remember we talked about
Yeah,
3 or 4.
next week Wednesday.
Our podcast is every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific Time. That will be 11 a.m. Mountain Time. And right now, to be honest, I'm not sure if it is 6 or 7 Nigerian time, because I think the time has changed. Have we changed the time lately? I don't know the difference, whether it's still 6 hours or it's now 7 hours.
Oh, it's 7. Oh no, so yeah, it starts at 6. Yeah.
So if it is 7 hours, it can't be 6.
No, it's 7 p.m. right now. in Nigeria.
Aha. So right now, 7 p.m.
So it
Nigerian
starts
time.
At 6, though.
Yes.
So we start at 6 p.m. Nigerian time.
No. 6 p.m. is 12 a.m. 12 p.m. here.
Yes.
So that means it's still 6 hours.
Yeah.
Maybe the time has not changed.
No.
Okay,
Yeah.
6 p.m. Nigerian time next Wednesday by God's grace. So see you then. God bless you.